Okay, we're going to get started this evening. Now, before I make any opening remarks and welcoming remarks to you, we'd like to open this event properly. And we have Dan Smoke here this evening. He's a traditional teacher. He's from the Seneca Nation, from the territory of Six Nations Grand River. He's going to do an opening prayer for us, and that's how we'll start.
Bujo, Sego, Suguli, Kolomose, Tanse, Wache. And welcome to this symposium on public inquiries with many sponsors here. We're very grateful to be asked to help with an opening that in our way, we want everyone to bring their good minds, their good intentions to bear to what we are going to be listening to and hearing from our esteemed panel. And so we want to sing a song to welcome in all of you as we gather here to bring our good minds here without any distractions. And we also want to sing a song to welcome in our spirit helpers, our ancestors. We are here on the land of the Mississauga people. We are also here on the land of my people, the Seneca people. My Seneca ancestors also settled here. These were gathering traditional peoples, and these were also agricultural peoples. So we're going to sing this song, and I'm going to ask my wife, Mary Lou, to come up and help us with that.
Bujo. In my language, when we greet one another, we say bujo, which means hello. It's kind of customary to say bujo or hello back. So bujo. Asanyenas Koya and Dejnakas Makwa Doda and Batchwana Bay Dunjaba. My First Nations name is Shooting Star Woman. I come from Batchwana Bay, Ontario, but live in London, Ontario with my husband Dan, and I'm of the Bear Clan. And the song that we're going to share with you is a song that we sing in our sweat lodge. It's a song that we sing to honor the eagle, and I want to share this song at this time to honor all the helpers that are here in the room, all the helpers to the people in the community. So this song is called the Migizi song, and this song was taught to us by a man who comes from Six Nations. So if you know the song, please sing along. And I came prepared. I have my beads as a musical instrument, so. Well, hey, hey, well, hey, hey, well, hey, well, hey, well, hey, well, hey, well, hey, bend again. Bend again, magazine. Bend again, magazine. Bend again, magazine. Way oh hey, 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 way oh hey. Way
Niawe, Miigwech, Mary Lou, for that beautiful song. Aho. At this time, I'd like to share a Thanksgiving in my language, the Seneca language, and in my wife's language, the Ojibwe language, a few words, and then I will translate that into the English language. Niawe, Sagwan Dizon, Miigwech, Gishem Nado, Yin de Gan, Mishomas, Senillo, Esquatahas, Ditcontanwa, Wahase, Jawise, Dodaqua, Oskada, Nagohas, Oeda, Anahas. Grandfather, hear our sacred thoughts, hear our sacred prayers as we come together in this sacred circle. We come together to celebrate Aboriginal Solidarity Day, and we come together to learn about the public inquiry and accessing justice for our peoples, for all peoples. Grandfather, we come together with our good intentions and with our good minds. We ask to be relieved of all the distractions that we may have encountered in our day. We ask to be relieved of all the stress, all the negativity, all the worry, so that, Grandfather, we come here and we begin from that same good place with our good minds. Grandfather, we also want to give thanks for this beautiful day that you have gifted us with, this Wani Slio, this beautiful day to celebrate life. We want to acknowledge all the life that lives in the water and all the life that lives on the water, for they are part of a life support for the water, and they are continuing to follow their sacred instructions, so be it in our minds. Grandfather, we want to acknowledge the water, which is the lifeblood of our mother, the earth, for the water is still a sacred element. All creation needs this water in order to live. So, Grandfather, the water is still following its sacred instructions, Grandfather, so be it in our minds. Grandfather, we also want to acknowledge and give greetings, give thanks to all the life that lives in our mother, the earth, and all the life that lives on her, the crawlers, the four-leggeds, the plant beings, the medicine beings, the two-leggeds, the rocks, the minerals, all the tree nation, all the life that lives in the trees, and all the life that lives on the trees, the flyers, for they are all part of a life support system, interconnected, interrelated, and Grandfather, they are still following their sacred instructions, so be it in our minds. Grandfather, we want to acknowledge our Father Sky for that breath of life he breathes into all creation, that breath of life that we all need in order to live, for our Father Sky is still following his sacred instructions, so be it in our minds. Grandfather, we also want to acknowledge our eldest brother, the sun, who is traveling across the sky world to the western door. And as he travels, he shines his light upon us, and he provides us that heat. Today being a very Wani Slio hot day. And Grandfather, we give thanks, we give greeting to our eldest brother, for he is still following his sacred instructions, Grandfather, so be it in our minds. Grandfather, we also want to acknowledge our grandmother Moon, who showed her face last week. And we want to give thanks, we want to give greetings to her, for she is still following her sacred instructions. She continues to look after all female life, and she continues to show her face and to purify and cleanse the waters, the lifeblood of our mother, the earth. So be it in our minds. And Grandfather, we want to acknowledge the star relatives for the star knowledge, for the star people tell us when it is time for us to conduct our ceremonies, which are for Thanksgiving, to thank you, Sagwayandizo, for everything that you have put here for us so that we may live. So be it in our minds. And Grandfather, we want to acknowledge the four thunders and the four protectors, those four celestial beings who look after all spiritual matters, Grandfather, for they have brought us all here together today because we know, Grandfather, that you love each and every one of us so much that you have brought us here to be part of this sacred circle. So in the spirit of our ancestors, we say Miigwech, we say Niawe, we say Tapwe. All my relations, Daneto, Natakiwasan, Kanigana, Hai Hai.
Now we're going to get on with the evening's events. My name is Tracey O'Donnell. I'm National Aboriginal from Red Rock Indian Band, which is outside of Thunder Bay. And I was invited here tonight as an elected bencher to chair this panel for this evening. I'm going to be the moderator for the discussions tonight. The treasurer of the Law Society wasn't able to be here this evening, so I'm extending his welcome to you on his behalf as we celebrate National Aboriginal Day here at the Law Society. This is actually the 6th year that the Law Society has celebrated this event, and we have done this with community partners to promote and celebrate Aboriginal peoples. I'd like to also acknowledge and thank some of those community partners who have, together with the Law Society, put this event together. And the partners are the Toronto Aboriginal City Celebration Committee, the Aboriginal Legal Services of Toronto, Lodi Odadjets, an Aboriginal Advisory Group, and the Association for the Native Development in the Performing and Visual Arts. It's with their partnership and their support that this event is being brought to you this evening. The Law Society is also very pleased to work with the Aboriginal Bar and is committed to fostering cooperative relationship. Over the past few years, the Law Society has been working together with Lodi Odadjets, who advise on a number of issues of concern to the Aboriginal Bar and the Aboriginal community. The Law Society looks forward to that ongoing relationship. Thank you for coming to this event this evening. I see a lot of you fanning your faces. It's warm in here. There's no relief from the heat. Sorry about that. But we do have a lot of speakers we're going to hear from this evening, and maybe they'll take your mind off the heat that you're suffering through. Now, we have a number of speakers to go through this evening. I want to introduce them to you. I'll do the introductions. We're going to allow the speakers the opportunity to address you, and after all the speakers have made their presentations, there's going to be an opportunity for you to ask questions of them. There's a microphone up at the front of the room here, so if you can come up to the microphone when you do have your questions, that would allow your questions to be heard by everyone else in the room. After this evening's panel session and questions, there's also a reception. You're invited to stay for that. There'll be food catered in this room here. There's going to be a women's hand drum group, Spirit Wind, that will perform a traditional song to open up the celebration reception. In the museum room, there's an art exhibit that is also open for your viewing after the panel. And now I'll introduce our speakers in order that they'll be speaking to you. First, we'll have Murray Klippenstein address you. Murray Klippenstein is the principal in the law firm of Klippenstein's Barristers and Solicitors based here in Toronto. Mr. Klippenstein's practice focuses on representing various First Nations, environmental, public interest, and other community-oriented organizations in litigation and organizational matters. He has represented the family of Dudley George for 8 years in their fight for a public inquiry and in their lawsuit against the Government of Ontario, Ontario Premier Mike Harris, various OPP officers, various cabinet ministers, and the Government of Canada. He will be representing the estate of Dudley George and 5 of his siblings at the public judicial inquiry related to Dudley's death. Next, our next speaker will be Delia Opekokew. She was educated at the law school, Osgoode Hall Law School, and the University of Winnipeg. York University, Osgoode Law School, and the University of Winnipeg. She's an experienced lawyer specializing in Aboriginal and treaty law. She's provided counsel to clients across the country. Other work experience includes being a commissioner on the Lachance-Nerland Commission of Inquiry, the negotiator for the Tall Cree Tribal Government of Alberta's treaty land entitlement, the negotiator for the Eel River First Nation of New Brunswick's loss of use claim, and the negotiator for the Canoe Lake Cree Nation in Saskatchewan settlement. Ms. Opekokew, who is also an established Aboriginal writer whose credits include work on the Royal Commission of Aboriginal Peoples 1996 and publications for numerous Canadian universities and the Institute for the Development of Indian Law in Washington, D.C. Born on the Canoe Lake Indian Reserve in Saskatchewan, Ms. Opekokew is the first woman to run for the position of the Grand Chief of the Assembly of First Nations in 1994. Next, we have Clayton Ruby. Clayton Ruby is a partner at the law firm Ruby Edward and a bencher of the Law Society of Upper Canada, where he chairs the Finance and Audit Committee. Mr. Ruby carries on practice in criminal, constitutional, Aboriginal, and administrative law. He represented Donald Marshall Jr. in Nova Scotia's Royal Commission into the Marshall prosecution. The Marshall Inquiry's report addressed the role of systemic racism in the wrongful conviction of Donald Marshall Jr., a Mi'kmaq man. The findings of that commission have had a profound effect on Canadian prosecution and policing practices, legal education, and criminal jurisprudence. The last speaker on the panel this afternoon is Don Worme, QC. Don Worme is a Cree lawyer and partner in the law firm Simogenis, Worme and Missons LLP. He is a member of the Saskatchewan Human Rights Tribunal and a past president and founding member of the Indigenous Bar Association. His practice is primarily criminal, and he has appeared before all levels of court, including the Supreme Court of Canada. Mr. Worme represented the Stonechild family in the recent Stonechild inquiry in Saskatchewan. That commission inquired into the circumstances surrounding the death of a Cree man, Neil Stonechild, and the possible involvement of police officers in his death. Don Worme has recently been appointed Commission Counsel to the Ipperwash Public Inquiry as well. So, Mr. Klippenstein.
Thank you very much, and it's a privilege for us to have you come out at the end of the day like this to join us. I would also like to congratulate the sponsors and the organizers of this event for the hard work in organizing something that's this important on such an important public interest topic as access to justice and the role of inquiries in access to justice for First Nations. It seems to me that events like this are an important part of the Law Society's role, for one, and it is good to see such an inclusive and forward-thinking event. In addressing the topic of public inquiries and access to justice for Aboriginal peoples, I have, as the saying goes, good news and bad news. Actually, I have some good news, and then some bad news, and then some good news in relation to the bad news, and that will be how I organize my comments. First, the good news. One piece of very good news is that there is an Ipperwash inquiry happening at all. I say that because every public inquiry is the product of the unique set of circumstances in which it occurs, and the circumstances surrounding the Ipperwash events were heavily stacked against an inquiry ever happening. In many situations where a public inquiry might be called for by a concerned or an aggrieved part of the community, there are often factors which tend to support the calling of an inquiry, which may make it very difficult or even easy, that may make it not very difficult or even easy or even imperative for the government of the day to call a public inquiry. An example would be when an issue arises which directly and immediately affects personally a large part of the public, so that a large portion of the electorate says, hey, I want answers about that because it could affect me. I think Walkerton is an example because we all drink tap water at least sometimes. There are many other similar things that in the circumstances may push towards an inquiry or make it rather easy for a government to call an inquiry. In the Ipperwash case, none of these applied. In fact, the opposite was true on every dimension, I think. Everything militated against an inquiry. In the Ipperwash case, it was several Indians who were shot, one of them fatally. Indians are not us, says John Q. Public. Furthermore, whatever it was they were doing at Ipperwash Park was certainly not something I will ever do. And weren't the Indians armed? Well, that's crazy. It sounds like they got what they deserved. And if the police got shot at, well, we have to support the police or there will be chaos, eventually even on my own street. And as for First Nations rights, they should just stop whining. And from the government's point of view, and that of the Premier himself, they might say, we certainly do not want any allegations of our personal involvement to get any kind of investigation or airing. There's no advantage to the government and its leading members from that kind of discussion. So if you analyze the circumstances of the death of Dudley George, all factors point away from the government or the Premier ever calling a public inquiry. But the family of Dudley George, led by Sam George, got an inquiry against all those odds. And that's the good news, at least for some people. Well, why in the end did it happen, given all those factors pointing away from it? There are many, many overlapping reasons. Some of those reasons are some pretty outstanding individuals, including, above all, Sam George. By the way, he was planning on being here today and called me halfway here on his 3-hour ride, and we discussed some family matter that had come up, and I suggested he just go back, so he sends his regards and regrets. But there were also the original counsel on the case and my former co-counsel, Delia Opekokew, who did some amazing initiation work on this matter, as well as Andrew Orkin, Peter Edwards, and Jerry Phillips, who also had an absolutely key role. And then there were the young lawyers in my firm, and many, many other people. But there were also a lot of strategic questions that we dealt with. For example, the George family had the option, given the factors that I just mentioned, of trying to wait out the then government and hope that a new government sometime in the future would call an inquiry. We considered that approach, but there were serious disadvantages. You don't know when the government is going to change. It could be 4 years, but it could easily be 8 years or 12 years. Ontario, not too long ago, was governed by the same party for 42 years straight. And it sometimes doesn't take very long at all for an issue to fade from people's consciousness. Even a year is a long time. Also, governments have thousands of demands on them, especially new parties who have been out of power for several terms. An issue involving a small minority of the population outside of major centers with potentially tricky spin-offs is not going to be a priority for a public inquiry in those circumstances. But for our clients and for us as lawyers, such a weak position, namely hoping for a change in government and that they would call an inquiry, ultimately wasn't good enough. We as lawyers believed we could do better for our clients and for justice and for Sam and the family, for Dudley, for First Nations, and for human rights. We believe that sometimes we have to settle for second best, but sometimes we shouldn't. So we needed to be creative and we needed to be astute. We had helped the family start a lawsuit because their initial searches for the most basic information had all been completely frustrated, and their options were very few. But over time, as more and more anomalies surfaced and stonewalling increased, we said to ourselves that public appeals for an inquiry are failing, and there is no law that entitles you to a public judicial inquiry. But what the law does entitle you to, in a limited way, in certain limited circumstances, is an open inquiry in a public court in front of a judge. At the entrance to the Supreme Court of Canada building in Ottawa, there are two sculptures, one on each side, one representing justice and the other representing truth. The family said, we want the truth, and if we're forced to go to court to get it, then that's the route we'll go. There are an awful lot of interesting legal issues about the civil lawsuit that the George family pursued. Technical legal issues, substantive issues, procedural, strategic. But as you know, we ended up in an inquiry, not a trial. So let me focus on that transition today for a few minutes in a behind-the-scenes kind of way. Throughout 8 years of the lawsuit, the family always clearly said that a public inquiry was the better solution and that it would drop the lawsuit if an inquiry was held, and that it would not settle just for money. In the end, I think the lawsuit was one of the keys to getting the inquiry. Personally, I think that if we had not pursued the lawsuit, the issue would have faded away many years earlier and disappeared into silence. People would have lost hope. The lawsuit provided a light at the end of the tunnel, albeit a very long and very dark and very difficult tunnel. There was hope that in some small way we would be able to obtain some small measure of partial justice in some form, no matter how overwhelmingly powerful were the resistances against us. I don't mean to leave the impression that the lawsuit was merely a tool or a lever or a means to some other end. And that's an important point. The lawsuit wasn't merely a bluff, and it wasn't merely a bargaining chip. The family was determined to complete the litigation if necessary, that is, pursue it through the trial, and, I might add, the inevitable appeals. Fortunately, that was not necessary. Here's how it played out at the end. Sometime in 2002, a trial in the lawsuit was set for September 2003. We spent most of 2003 in very exhausting trial preparation. Then the provincial election ended up being called for exactly the same time. This created some very interesting and very complicated possible scenarios. In the end, it came down to this. The election was set for Thursday, October 2. Our 6-month trial was scheduled to begin 3 days later, on Monday, October 6th. As the days ticked away, the position of the family was always the same. An inquiry was better than a trial. It's easy to forget in hindsight that during the election campaign, as we were in the last crazy days and nights of trial preparation, it still appeared that there was a very real possibility that the Conservatives would be re-elected. If they won, no inquiry. And if the Liberals won, who knew? The Liberals, including Mr. McGuinty personally, and especially Liberal MPP Jerry Phillips, had promised an inquiry. But if they were elected, there were 8 years of pent-up demands that would be screaming for their attention. The new Premier, of course, would be the center of a storm of immediate challenges. And although we fully trusted the commitment of Jerry Phillips to an inquiry, we did not know if he could carry the day with his colleagues. To make things more complicated, we believed that if the Liberals won and the trial started 4 days after the election, the odds of the new government calling an inquiry would immediately drop dramatically. Calling a public inquiry once a major trial had started would be very confusing to the public, would look wasteful, and would look possibly disrespectful to the court. Furthermore, once the trial had started, we could not unilaterally drop the trial to pursue an inquiry, nor could the provincial government, because it was not the only defendant, and the other defendants probably wouldn't agree. There was one way out. We had received a financial settlement offer back in August, a formal written offer under the rules of civil procedure. We had immediately rejected it, saying that without a public inquiry as part of the package, there would be no settlement. But the offer was still on the table. Why not wait until after a Liberal win and then instantly accept the offer, thus ending the trial and clearing the way for a new government to call an inquiry? The problem as we approached Election Day was that the offer could be withdrawn at any moment. And we believed it was at risk of disappearing at any moment. We believed that the defendants might see it as very much in their interest, as a Liberal government began to look like a real possibility, to withdraw the offer so as to lock us into a trial rather than an inquiry. In fact, we were explicitly told late on Wednesday, the afternoon before the election, by one of the defendants' counsel that the offer might be withdrawn at any moment. But if we accepted the offer before the election to end the trial, to clear the way for an inquiry, we had no guarantee that the Liberals would win, and if they would win, that they would call an inquiry. I should add that we were not political insiders, and we had no political or personal connections or influence in the Liberal Party. There was no hidden deals. So on the evening before the election, we had a conference call. When all was said and done, we believed in the commitment by Mr. McGuinty, and also that if the Liberals won, Jerry Phillips had the personal integrity and the clout within the Liberals to carry out what he had for 8 years obviously believed was the right thing to do. I was given the authority to monitor the news and accept the offer if things looked good. The next morning, I arrived at the office at 5 a.m. and hung around the convenience stores near my office until the morning newspapers arrived. The outcome on Election Day was still not clear, but I scoured every newspaper sold in Toronto, and there was not a single commentator in that morning's papers who would come out and say that there was any hope for anything but a Liberal majority. So at 7:10 that morning, on Election Day, I faxed out Sam's acceptance of the settlement offer. If our guess was wrong and the Conservatives were re-elected, we had lost the trial and we had lost the inquiry. Sam says those 24 hours were some of the most nervous of his life. I must say that I felt very good on Election Day because there was no doubt in my mind that it was in the bag and that after 8 years we had arrived. In the early afternoon of Election Day, news of the settlement broke out on the radio, leaked by several defendants, including Mr. Harris, who wanted to claim vindication and I guess perhaps attempt to influence the election. A reporter asked me about Mr. Harris's public claim that the settlement fully vindicated him. I said, I think that's referred to as peaking too soon. I got a frantic phone call later that afternoon, still early in the afternoon on Election Day, from the Liberal campaign office saying, what's this all about? What's going on? I said, the George family accepted the settlement to end the lawsuit because they now believe the Liberals will win the government, and they trust Jerry Phillips and Mr. McGuinty and believe that Mr. McGuinty will keep his promise to hold an inquiry. And we meant that when we said that. And then I said to him, and by the way, if you don't call an inquiry, we'll be suing your butts for the next 8 years. And we meant that too. I can tell you that Sam and I had a pretty emotional phone call that night after the election results were in. The next morning at Queen's Park, in his very first appearance as Premier, or Premier-elect, Premier McGuinty stated he would call the inquiry. So the good news is that an inquiry is sometimes possible even in the most difficult circumstances, and even when it's an awful uphill struggle. I think there's more good news about the inquiry itself. The good news is that the inquiry has some resources to investigate the issues to a greater level of thoroughness than we could ever have, and that's good news. There's another advantage, and that is that an inquiry, while it is a legal process, it is not a court. And it can look at things, including legal subject matter, from a different perspective. We think that the Canadian legal system failed the First Nations people at Ipperwash in relation to the Stony Point Reserve and Ipperwash Park. And it failed partly because the substantive law was discriminatorily shaped against Native people. I think the inquiry could and should examine that issue, and ultimately we believe that the inquiry should review what can be done about treaty lands that were obtained by non-natives through so-called surrenders. We think the general principle in this province and beyond should be that treaty lands should be returned to native possession. The former Ipperwash Park and the death of Dudley George show why. Let me say something about bad news, and I think I'm over time, but Don Worme told me at the beginning of the panel that because of his new position, he can't say too much, and I can have his time. I hopefully can share that time and won't restrict him, but a couple of more thoughts. Some of the bad news. The cost of getting to an inquiry can be staggering, absolutely staggering. For Sam, personally, it was unbelievable. From a more legal perspective, the settlement which we were forced to accept included indemnification or repayment of legal costs on a partial indemnity scale, or party-and-party costs, as it used to be called. We just completed a preliminary calculation of that, which in itself is a tremendous amount of work. And just for my firm, that figure comes out to significantly over $1 million. That doesn't include, because litigation generally, perhaps in this case, makes no allowance for the kind of fundraising work and time we did, or for the public information work we did, or for the many, many motions on which there were cost orders dealt with during the process of the litigation, and in which orders were made. There's also, as you know, you may know, the difference between partial indemnity and full indemnity. If you add in all those factors, I think a realistic assessment of the actual cost legally of doing this would run into several $1 million. That's the cost of getting a public inquiry. We don't have that money yet, and I have no idea when we'll get it. And we have always made the commitment that the net proceeds of this matter, after paying expenses, would be devoted to a fund committed to Aboriginal rights and human rights. And that's going to happen. But I say this all as bad news because you need to put that into the equation. And it is a pretty terrifying equation. Another piece of bad news, one might say that now that the inquiry has arrived, things are much, much better, and that is absolutely, certainly true. But ironically, the funding decision for the inquiry treated the Dudley George Estate and SAM group more or less the same as most other applicants, with the result that after 8 exhausting years, we will in fact probably have to reduce our efforts in the inquiry. And I suppose that's good in a way, but I think it probably deprives the inquiry of our accumulated experience and our ability to apply some of the things we learned, and has been a bit disconcerting. Some good news about the bad news. The issue of those financial impediments to seeking the kind of justice that the system has to offer can be partially overcome, and I think it involves, and I won't get into it now, but it involves some good old values and certain institutional and organizational values, which I call, and this sounds a little odd perhaps, but I think that we tried to apply the values of frugality and creativity and astuteness. And although it sounds a little corny, I think that when you actually work on that, it can make a very large difference in a very difficult situation. Finally, and this is also some very good news, I guess, out of that bad news, I received a phone call from a young lawyer just a few days ago. During the last year, I had had quite a few discussions with her about the Ipperwash case, without breaching any confidentialities, of course, but she knew the case quite well, including the kinds of difficulties I've mentioned, and including the kinds of administrative and back office challenges it created. In particular, I had told her many times, and I quote, that this is 10 times more difficult than you think. She herself had recently come to a fork in the road in her career. This lawyer happens to be a very talented person with an exceptional track record, who I think essentially could have her pick of any job in the country, with any firm or any government, at the highest salary going. But when she called me, she said that she had decided to go into a very modestly paying position with little job security, in part to try to advance Aboriginal rights. And she said that what she had seen in the course of the Ipperwash case had maybe helped her to think that such a thing was worth doing. I found this personally pleasantly surprising and very encouraging. I invite all of you, whatever position you are at in your legal career or otherwise, to also reflect again on the opportunities for us as lawyers to work for justice with creativity and astuteness and yes, even frugality. Thank you.
Thank you for your comments. Again, just to remind you, there'll be opportunity to ask questions at the end of all the speakers. Next, we'll hear from Delia Opekokew.
Oh, thank you. And thank you for inviting me to this panel. I will get right into the heart of my speech, which relates to the Commission of Inquiry that was convened in Saskatchewan in 1992, so it's quite a while. The commissioners were Ted Hughes, Peter McKinnon, and myself. Our inquiry was established because of the extraordinary concerns expressed by Aboriginal people and other interest groups about the administration of justice as it affected the shooting of Leo Lachance, an Indian person, by Carney Milton Nerlin, a known white supremacist, in January 1991. Mr. Nerlin entered into a plea bargain and was sentenced to 4 years imprisonment. As a result, there was no evidence that was presented, and that's the normal case in a plea bargain. Various questions were raised as to what actually did happen, and about the background attitudes and activities of Mr. Nerlin. Our inquiry was struck, and our terms of reference included for us to inquire into the correctness and adequacy of the police investigation and whether the appropriate charges were considered. I think I mentioned earlier that the charge was manslaughter and he got 4 years. We were to look at the prosecutorial process in deciding what charges were to be laid and in relationship to the incident. The Crown and legal process applied in disposing of the manslaughter charge, and the process applied in allowing him to operate a gun store and to have the license to use the weapons. We were also looking at racism. To what extent was racism a factor in the shooting death of Leo Lachance? We were also asked to consider whether organized racism itself was a factor that was so serious in other areas aside from the Mr. Lachance incident. In January 28, 1991, Nerlin was in his gun shop with two friends and customers who, by the way, happened to be both employees of the government of Saskatchewan. At about 6:15 p.m., Lachance entered the store, spoke to Mr. Nerlin and to one of the customers. As he turned, there was 2 shots to the floor of the store. Then as he left, there was a 3rd shot that killed him. The police investigation concluded that Mr. Lachance had been shot outside the door. And because it had taken place outside the door, that it went through the door and he was sit outside the door, they considered that fact to be so important and said that the shooting was an accident, and thus that the only charge that could be laid was manslaughter. Because they considered it to be accidental, they did not explore the racism that was known. It was known that Mr. Nerlin was racist. At our inquiry, we found that the evidence was unclear. We had brought in an RCMP sergeant who was connected with the forensic laboratory in Regina, and he did tests using the door itself, and he tested it by shooting from the type of gun, a machine gun. It was a European machine gun that was used, shooting bullets through the door, and it showed that those bullets that went through the door had markings on them. Those bullets that did not go through the door did not have any markings. The bullet that was retrieved from Mr. Lachan's body did not have markings. Therefore, it was our conclusion that the question was left open as to whether the shooting was intentional or accidental. But we did not have the authority to open up the matter so that other charges could be laid or manslaughter to be changed to murder. We could not extend the sentence, but we could examine exactly what had taken place. Because we questioned whether it was accidental, we felt that we had to look at Mr. Nerlin's history as a racist. And some of the words that I'll be using are very harsh, and I'll apologize in advance. But because our inquiry ended up being focused on racism, some of these words had to be stated because that was the evidence that was given to us, which we in fact accepted. Since 1984, Mr. Nerlin had been a member in the Church of Jesus Christ Christian Aryan Nations. This was a white supremacist group whose standards and goals were revealed to us in the evidence. They had a central headquarters in Hayden, in Idaho, where white power groups from all over the world met. Each year they met to organize their action plans. They believed that North America was intended to be all white. They had a battle plan on who to kill and appoint system. If, for instance, you killed a person, a high-ranking person who advocated equal rights for all, you earned the highest score and were awarded the highest rank as an Aryan nation. However, I do believe, as a change as to what events occurred in when we explored this matter, that compound no longer exists. My understanding is that there had been a number of shootings, and eventually that compound was seized. Nerlin had been appointed to the Aryan Nation, the Church of Jesus Christ Christian Aryan Nation in Saskatchewan in 1989, to be the head or the president. He attended an Aryan Nation feast in 1990. Keep in mind, we're speaking about 1991 events. He had attended in 1990. There he was head of security and provided the guns for the event. He appeared in military type clothing with a Nazi armband featuring a swastika. For the cross-lighting ceremony after dark, he wore a Ku Klux Klan outfit. He had joined the Klan in 1984. The reason why there's a record of this is that there was an inquiry over it, and plus there was a court case. The court case was referred to in R.V. Zundel, in which the Supreme Court of Canada stated that the facts in the recent case of Kane v. Church of Jesus Christ Aryan Nation reveal with dreadful clarity that racism is a current and present evil in our country. Some of the statements that Mr. Nerlin made were recorded because there were protesters there from different groups who respected the equal rights for everybody. Some of the statements he made are absolutely terrible. Making fun of people's history, yelling out that, well, it was just very awful. We heard all of that. All that evidence was presented to us. So that was 1990. By that year, the 1990, when he had the gun shop, the gun shop as it was in 1991, January 28, when the shooting occurred, one of the witnesses, who was a friend of Mr. Nerlin, testified that Mr. Nerlin occasionally expressed racist views against the Aboriginal people of this country, blacks and others. He had his gun shop was decorated with pictures of swastikas, a picture of a black person with a red line through the face, which was described as meaning that no black people were allowed in. Another witness, which was ironic, that appeared before us was Darwin Bear, who himself was a native, but he did not associate with his own community. He stated that he was not concerned by Mr. Nerlin's statement that if he was convicted of the Leo Lachan's death, that he should be awarded a medal because he had killed an Indian. During his incarceration and prior to the sentencing, he made statements to the police officers. He was asked if he had a lawyer, and he said, yeah, I was looking for a nigger lawyer. They're a disgusting race. He continued making that kind of statements in relationship to, not just to black people or Jewish people, but also to Chinese people, all in that period while he was incarcerated. With the Indian people, he mentioned some 92-pound Indian with a butter knife says he's going to kill me. Yeah, right. Then he went on, nice of the department to send a couple of white cops. I think the most significant crisis for me, it was absolutely difficult to sit through that inquiry, was the lack of recognition and awareness that the players had about the role of racism in our society and how damaging it is and how hurtful it is. It was shocking to know that an Indian person, a Cree person, had been killed, perhaps only because of who he was. I think the most serious thing that we could have done as a commission of inquiry was we took seriously the concerns that racism was a factor in the death of Mr. Lachance. At the end, we made recommendations. But the greatest disadvantage we had was that a motion was filed against our inquiry by the RCMP, and they obtained an order successfully from the Supreme Court of Canada, preventing us from asking questions on Nerlin's statement that he had been only role-playing and in fact was not racist. The RCMP had another curious role which was that one of the officers traveled from Regina to Prince Albert 1 or 2 days after the shooting and advised the Prince Albert police that Nerlin would flee the country if released on bail. Also that they had information that his racist beliefs did not play a major factor in the shooting death of Mr. Lachance. But after all the evidence we heard, it was we accepted that it was not role-playing, that he was a racist, and that played a factor in the shooting death of Leo Lachance. So in our findings, we identified that the police and Crown did not pursue all available avenues on the question of Mr. Lachance's physical location inside or outside the store. We identified that the police and Crown so quickly embraced the probable accidental shooting theory, and that was a problem because they continued to be committed to the position when they should have recognized the need for an in-depth investigation of Mr. Nerlin's background, because it was widely known. The police admitted that they knew that he was a white supremacist even before the shooting. We identified that the Crown Counsel at the sentencing hearing was too passive when the defense counsel said that there was nothing related to race involved in this incident. It was plain and simple an accident. The wrong was the outgrowth of the deficiency identified with a quick embrace of an accidental death. We identified the shortcomings for allowing Nerlin to be in possession of his business license, sanctioning his operation of a gun in the city of Prince Albert. And as I stated in closing, we spoke harshly against racism. And I think that hearing affected me so much that when in 2002, when one of our own people, David Hennekew, made those infamous racist statements against the Jewish community, that I was just so appalled that I spoke out vehemently against that. It was such a shock to know that that kind of reaction can be made by anyone, even into today. And what is also very sad is that some of our own people make those statements against other races. And in fact, it is my belief that Mr. Lachance would be alive but for those racist attitudes and for the system allowing it to continue. Thank you.
We finally have it. Benign government has granted us this Royal Commission. It's about to start its work, and the world looks better. Let me try and suggest to you that planning a strategy to deal with the Royal Commission requires very careful and critical analysis of what they are and what they do and what they do not do. Let me give you some of the elements of that analysis in a very basic way. First, you must stop believing all the things that the Royal Commissions tell you about themselves and their role, what the textbooks tell you about themselves and their role, what the academics tell you about themselves, about the commissions and their role, and what governments tell you about Royal Commissions and their role. You must look at what Royal Commissions actually do and draw inferences from that rather than from the myths. First, governments do not call Royal Commissions because they want the truth. Governments do not call Royal Commissions because there's a social problem that's urgent that only a Royal Commission can solve. Governments do not call royal commissions because the Royal Commission itself is a good instrument of government which has some powers that make it an excellent source of governmental behavior and action and recommendations, such as the subpoena power, the independent judiciary who sits on it, and so forth. None of these myths are true. They're lies. Governments call royal commissions for primarily three reasons. One, to remove a political problem from the political arena where they will have to deal with it into a more neutral, semi-judicial arena where they will never have to deal with it. Two, to delay public consideration of a political problem to a point in time when it becomes more advantageous for the government to deal with it. Three, to hurt a political opponent. Ipperwash. If it was the same government, they never would have called this Royal Commission, only because it's a different government who figures they can bruise the Tories along the way, though all the noble endeavors suddenly become imperative. Sure. Governments traditionally choose good people as commissioners, honest people, honorable people, intelligent people, and the commissioners generally want to do an honest, good, intelligent job, and they work hard at it. And they in turn choose as counsel good people who are honest and honorable people who want to do a good job and work hard at it. All that is true. Everyone wants to do good, to accomplish something and leave a mark of some kind to make the world a better place. And yes, along the way, during the Royal Commission, interesting things happen. You get to ask fascinating questions of people who otherwise would not be amenable to questioning, and you get to command answers. This is important and interesting and fun. And if there's funding for counsel, proper funding, then that's an excellent thing. Most of these commissions underfund drastically. So it's a huge sacrifice for counsel. And many groups don't get funding for anything but the social part of it, which means the day-to-day questioning is not there and not done. You can do interesting things along the way in the sense that the Moran, well, take the Marshall Commission. We found at one point that the Court of Appeal judgment which dismissed Marshall's appeal on a murder charge in Nova Scotia was in part dismissed on the basis of matters which were not in evidence, matters which were never found in the record, of which there was no evidence under oath, and which were never stated because of the transcript in the Nova Scotia Court of Appeal, were never stated by counsel to the court. So where do they get these facts? Well, the answer is they didn't make them up. Somebody told them these facts. And they told it to them outside the courtroom. So the commission subpoenaed the Court of Appeal judges and said, we want you to come and tell us where you got this information from. And we went all the way to the Supreme Court of Canada to find out, of course, that we couldn't do that. That no one could force the judge to answer questions except the Judicial Council, and certainly not a Royal Commission. So we had a nice time. It was fascinating for the lawyers. A nice little trip to the Supreme Court of Canada, but we didn't achieve much but an interesting ride. There are some narrow good things that can be achieved fairly easily by Royal Commissions. One, you really do correct the record. If someone's wrongfully convicted, if there's a wrongful death, you create a new record and it does in fact count. That's worth doing. This is a very expensive, lengthy way of doing it, but it's worth doing. Second, you may create along the way new heroes or new villains. You create a mythology of your own about the event. And it's a good thing to do, have a chance to do that, because generally speaking, the event's over and gone, and somebody else has created the heroes and the villains. Third, you can get money. This is much better than civil lawsuits. It's more interesting, more independent, and it's good that people who've been harmed and wrongfully treated should get money. These are all good things, but they're small things. The big thing is the Royal Commission report. But I tell you, the truth is that the Royal Commission report will sit on a shelf, and sit on a shelf, and sit on a shelf. And 3 months later, no one will remember it. And almost no one will have read it other than the first press reports. The number one recommendation in the Marshall Commission report, and it was put number one because it was regarded as being the most important one, was to create an independent agency to investigate allegations of wrongful conviction. No one's ever acted on it. As far as I can tell, no one's ever going to act on it because it costs money and would embarrass governments. There it is. One more recommendation on a shelf. Rarely you have a situation like that of Justice Corey in Manitoba in the Milgard case, where he starts talking about identification evidence and its weaknesses, and the courts pick it up. The courts are much more amenable to acting on what a Royal Commission says and develops in terms of ideas than our governments. Just rarely happens any other way. In the Moran Commission, you found a whole body of developing law about informers and the dangers of informers. Governments haven't done hardly anything about that, but the courts have picked it up and been so sensitive to it. So it was a sensitizing process that makes the courts act, but not governments. Legislation in response to Royal Commission reports is almost unknown. Sure, there's a wonderful new technique. It's always part of the report. They go into the social issues, the psychological issues. They have experts come in. They have roundtables. It's touchy-feely. We invite the native people in those things. We want to hear what you have to say. That's your forum. And we issue a report on that, but nothing ever happens. So, if you're going to plan a strategy and you know all these negative things, what does happen that's good out of a Royal Commission, and how do you influence that? Well, the first answer to that question is, what's good about it is that the press follows it every day. And as far as I can tell, that's the only good thing. So if you're planning a strategy to deal with Royal Commissions, step number one is make sure the Royal Commission has proper press offices and officers, that there are people to coddle them, explain it to the guy who walks in because he's a third stringer and only there for 3 days, to have background papers, extensive briefings, to coddle the press, because that's what the Commission is really all about, affecting public opinion on a daily basis. Only in this respect is a Royal Commission, in my view, worth the time and effort that you put into it. Thank you.
Thank you. And our last speaker that we'll be hearing from this evening is Don Worme.
Good evening, everybody. My Indian name is Dances with Worms. I know, it's not as sexy as that other guy, but what the hell. Just maybe just an observation before I make any comments. Seems to me that, we used to have like 365 days a year. Then we got cut down to Indian summer, and now we got Aboriginal Day. I don't know where that came from. Let me first of all just start by thanking the very eloquent and capable panelists here that I have the privilege of speaking with, particularly the sartorial Mr. Ruby here beside me, who just ran out of court in order to come here. And very good comments. I appreciate that very much. I want to thank as well the Smokes for your opening prayer and that prayer song, and we value that. And it's important for us as human beings to recognize that there is other planes and other things that we need to maintain some focus on in order to live our lives in a good way. And so I thank you for that. And of course to the organizers, to the Law Society of Upper Canada, and for the privilege of attending here, and obviously to you for being here. The good news, as Murray would put it, the good news that I have is that mercifully I will be brief. I will talk to you about, or I will not rather talk to you about the Upper Wash inquiry. I think Murray has already given us a very good sketch of what has, the enormous effort that has gone into having this inquiry called. But I can tell you, I think, at least in generalities, about the Stonechild inquiry that has recently been completed. I will not obviously speak about what my hopes and wishes are in that sense, simply because after 43 days of hearings spread over a year and a half, we are still awaiting a report, and we expect that report to come out at some point at the end of this summer, perhaps. And I am loath to attract the wrath of Commissioner Wright by making any kind of predictions or otherwise. But let me tell you about Neil Stonechild. First of all, as his mother had said when she took the stand, in fact, the last thing she said when she was on the stand, is that he was not a man, but rather he was a boy. You know? And it was a very powerful moment, because I think it really resonated at that point in time with other people, with other parents, that there was something very, very terrible that had occurred here. Because the press, Clay makes a very good point. It is important that in inquiries, in royal commissions, that there is a proper manner in which to deal with the press. And the press had a field day with this story initially, because, I mean, they reported that this was a drunken man, he was found dead, and that was the end of it. And indeed, that was the story that the Saskatoon Police Service had initiated back within hours of the discovery of this boy's frozen body in a remote north end of Saskatoon. So, he was found on the 29th of November, as I've indicated. It was in the north end of Saskatoon, and actually not too far from the Saskatoon Correctional Center. So the person that was charged with investigating the discovery of this frozen body spent a total, as we found out through the inquiry, of 4 days on the job, which amounted to less than 20 hours in investigating. He didn't follow up on leads. He didn't do all kinds of things. It didn't strike him as odd or unusual that there was no means, or at least readily available means, for this boy to have ended up in that location. It didn't strike him as unusual that he was missing one shoe, that he had his sock was worn through on his unshod foot, that he had these numerous abrasions, as they were called. We think of them as cuts or scratches or bruises that covered his body, and particularly on his face. 2 precisely parallel wounds across the bridge of his nose that, not coincidentally, matched Saskatoon City Police handcuffs circa 1990. And so all of these things was very strange, and having said that, that was the extent of the investigation. I mean, we spent more time in the inquiry looking into this boy's death than was ever actually undertaken by the police service itself. And the only reason that this case had ever seen the light of day again, no thanks in large measure to the Saskatoon Police Service and their vehement denials that there was a shabby investigation and ongoing press releases and feeding the press this misinformation. The only reason that it made it to see the light of day was that it had been raised during the course of a massive RCMP investigation that occurred following Daryl Knight's revelations, stunning revelations, because he was the only survivor, that he walked away from being dropped off on a minus 25-degree night in a remote area of Saskatoon. It seemed like the modus operandi was pretty apparent. And the grisly discovery of 2 other frozen Aboriginal men in within a couple hundred meters of where Daryl was dropped off, within days of his public revelations. At the same time, there were also several other Aboriginal men that were found dead in Saskatoon shortly after their release from police custody, one of which was a freezing death. He froze to death on the front doorstep of his apartment with his jacket still in hand that was given to him at the police station. So all of these things sort of came together to trigger this massive RCM police investigation. And during the course of that, we were approached by Mrs. Stonechild, or Stella Bignell actually, to see what we could do about having this probe look into it. So I think, as Murray said, it's not so much the massive effort that is undertaken in every instance, but sometimes a combination of other, perhaps unfortunate, but other coincidences that actually triggered the call in this instance. And at the end of the day, well, we've had, as I've said, we've had 43 days of evidence. We've finished the final arguments. We've heard the evidence. In my mind, I mean, I think I know what had happened, but whether that will coincide with what the report says is another issue. What I do want to make clear, though, is that we represented every one of the estates of those frozen individuals, as well as Daryl Knight, and we have brought civil actions on each one of those. And I think the important thing, and this is something that Clay has mentioned, the important thing is that these issues get on the burner, and that is the primary purpose, in my view, of public inquiries, that they are on the burner, that it gives us an opportunity as a community to reflect on these things, and perhaps to educate, and perhaps even to act. And as Murray had indicated, you know, when he gets calls from young people, they're inspired to act, and they're inspired to do things, to fight for a social justice, to fight for the kind of society that our children deserve, and deserve to live in together. With respect to the challenges and advantages of the public inquiry model for promoting access to justice for Aboriginal people, well, I agree with my colleagues. I agree with Murray's comments, and I certainly agree with Clay's comments. Public inquiry is not a court. It is tremendously expensive, and it's not voluntarily called. You have tremendous competing interests. You know, it's a very strange process in a lot of ways. It's a process that pits David against often not just one, but several Goliaths, with people with tremendous resources at their disposal to be able to do all kinds of things. And the inquiry process does something, I think, to flatten that out and provide a playing field, not necessarily level, but at least a playing field that one can participate in. The one thing that I do want to make clear on, with respect to our representation of these various interests, is that we are not against police. In fact, we're against bad policing, and there's a huge distinction to be made, and that must be made at all times. I mean, if somebody's breaking into my house, the first people I'm calling is the police, as would everybody else. But there is a definite need, because these are institutions that we give as a society such tremendous power to, that there needs to be certain oversight, that there needs to be, well, unfortunately, public inquiries sometimes to provide that kind of oversight. What do we need? I think we need a new model for policing, certainly. I think a model that's based not necessarily only on law and order, but rather one that has perhaps as its centerpiece human rights. And it would seem to me that at least that was the approach that was taken in the reconstruction of Northern Ireland. You can go to the website of the OCC, where they have done tremendous and fascinating work in terms of reconfiguring the policing that's done in that country. And it seems to me that that may well provide a model for us here in this country. I think that's about brief enough, but I do want to say again that I thank the organizers of this, and I thank you all for your kind attention, and I look forward to working with many of you, you know, as people of goodwill and common cause to developing that kind of society that our children will inherit if we do our jobs. So thank you.
First off, I'd like to thank each of the presenters this evening for their comments. We heard Clayton Ruby challenge us to look at the realities and the myths of royal commissions, and perhaps those same realities and myths exist for public inquiries as well. Murray Klippenstein reminded us about the cost of obtaining truth and justice, and that cost is sometimes personal and sometimes at great cost. Delia focused our attention on racism that exists throughout our communities and how ugly and destructive it can be. And we heard from Don Worme when he informed us, as the other panelists did as well, that at times that there were a number of coincidences or circumstances that came together and that were present for the call of the inquiries that we heard our presenters speak about. The need for inquiries make it clear, I guess, to the panelists and to all of us here from hearing from them that Aboriginal peoples are still seeking justice and recognition of their rightful place in their home, in their home territory. Is there any questions or comments from any of the people here tonight before we conclude this portion? Yeah, if you could you come up to the mic, because then everyone would have the benefit of hearing your question or your comment. Thank you.
I'm Jeffrey Stutz, and I'd like to ask Delia Opekokew if, from your experience with the LaChance and Erland inquiry, whether you could point to any successes, any recommendations that were implemented that for you represent a gain out of the process.
I cannot specifically point at anything, but generally it was my view throughout the hearing that the success of the inquiry is the fact that the information came out, particularly for the First Nation community in Prince Albert. There's a large First Nation community, and that community was very hurt and angry with what had happened. And the fact that inquiry took their complaints very seriously, I believe, really assisted them. Again, nothing that I can say specifically, but just in coping with everyday life in the city of Prince Albert.
Hi, Andre Morisseau. And Mr. Worme, if I may. What is, we're talking about inquiries, and maybe Mr. Ruby, either of you, what kind of success does the American system have with their Aboriginal peoples and inquiries? Do they hold inquiries? Do they have a better system? Or is our system better than theirs? What is the comparison? Open-ended question, but is there any?
I have limited experience in America, but I can tell you that from the people that I've dealt with, other American Indian attorneys, their position is number one, there is no such thing as a public inquiry there. They do have other processes, primarily through their governments, but nothing like the inquiry. I think it's distinctly probably English. Whether they have any further successes, well, clearly if they don't have these kinds of processes, they don't, we can't really measure against what kind of successes that they do have, but it's also, it seems to me, my view that there is a different basis for the rights that they assert in the United States. For example, the treaties are recognized essentially as constitutional documents in the Americas. They don't need to be enacted through other legislation. Having said that, they are often respected in the same fashion as they are here, which is to say they aren't. So.
I just had a question, because a number of you have talked about the history of Aboriginal peoples in Canada, the kinds of systemic racism that exists and so on. And it seems that some of the questions or concerns around public inquiries tend to be rather narrowly focused. dealing with, for example, Ippawash and not the greater issues of the relationship between the Canadian government and Aboriginal peoples. I wonder if there's been any examination into issues around or approaches of truth and reconciliation that have been used, for example, in South Africa, in Thailand, and Cambodia, as a way of getting at some of the broader issues and trying to look at both the importance of public awareness and education, while at the same time a process of long-term healing.
Well, what comes to mind is the Royal Commission on Aboriginal Peoples that has looked at coexistence and solutions for it. But as you know, the courts have referred to it a number of times in many of the cases, but the government really has not followed their recommendations.
Any other questions or comments? There's, the air conditioning's on now, so she'll be cool and comfortable. It's not too much effort to get up to the mic. Okay, if there's nothing else that anyone would like to say or any other questions, then I'd just like to say thank you to all of you for coming here this evening. I'd also like to say thank you individually to each of the presenters for coming here today to share your experiences with us and for answering the questions. Okay. Rudy, I'll hand these, our gifts, our small thank you gifts to you. Now, all of you are invited to stay this evening. We have a women's hand drum group, Spirit Wind, who's going to do an opening for the next part of this evening's events, a celebration. They're here if they could come up to the front, please.
We're offering the Megaze honor song. If you all could stand up. We'd like to honor the prayers that go out for our people and all the hard work that people do to protect our people from incarceration.
Bojo, we're going to sing a song called Star Song, and it's to do with our connection as human beings to the stars. And yes, you can sit down and relax. And yeah, it's about our connection to, you know, and rising to that level. Look up in the sky and you see all those beautiful stars, and we believe that's where we come from originally. And so we're really connected, all of us together, and to the stars. last song that we're going to do is, it's about where you're coming from, then reaching, staying in the present and keeping your mind in the present, and then where you're going to go too, because you always need to keep your feet on the ground, but you need to kind of know where you're going, where you're coming from, so you can get where you're going. And so this is called Past, Present, and Future. And keep on doing what you're doing. It's all good. Look into the future.
Thank you. Miigwech, thank you to the Women's Hand Drum Group. We're going to have a reception here in this room. There's also a fine art exhibit in the museum room. If you go out this door here, up the steps, and there's a room right up at the top of the stairs there. So you're also invited to visit there as well. Thank you again for staying with us tonight.
I was part of it.